When you're a business owner or self-employed, the financial ramifications of divorce can take on a different meaning. What happens to your business interest? How is the non-owning spouse compensated, if at all? Hi, I'm Keenan Goldsby of Schonbach, and I've been practicing family law in Northern Virginia for nearly 20 years, during which time many of my clients were in this exact situation. Virginia divorce law provides that a party's ownership interest in a business can be considered marital property, making it subject to equitable distribution. The court is required to place a value on the owner spouse's interest and uses that value to compensate the non-owning spouse, usually with a monetary award or with a credit in some other marital assets. The court cannot transfer ownership of a business interest, which is owned individually by one spouse, to the other spouse. This makes the valuation of a business interest a very critical component of your case. It requires a complex analysis, which is typically conducted by a forensic accountant or business valuation expert. This expert must review complicated and often voluminous financial documentation and conduct an investigation of the business to formulate an opinion as to its value. In conducting this analysis, the business valuation expert needs to be familiar with certain nuances of Virginia law, including the applicable valuation standard based on intrinsic value, which is different from fair market value, and the fact that any part of the value which can be attributed to personal goodwill is not to be considered part of the value of the marital property. As you may imagine, the analysis is often time-consuming and expensive. At Schonbach, our attorneys have close working relationships with numerous forensic accountants and business valuation experts who regularly value closely held business interests and appear in Virginia courts to testify as to these values. We know the right questions to ask and understand the areas which require emphasis. Why is this of the utmost importance? Because it allows the valuation process to be streamlined and efficient. And when the expert is able to do his or her job in the most efficient manner possible, the client is better served. Our attorneys and paralegals are also well versed in understanding the extensive documentation which will be required for the expert to conduct his or her valuation. We provide valuable assistance when our client is the owner of the business interest, as he or she is compiling that documentation. In those cases where we represent the non-owner spouse, we're equally well versed in which documents need to be obtained in discovery so that the business valuation expert has what he or she needs to correctly value the business. If this sounds overwhelming, it can be. But by working as a team with the business valuation expert, our attorneys and paralegals can make the experience bearable for you. If the parties do not agree to a joint valuation of the business, there will usually be a business valuation expert retained by the other side. Our firm's experience in handling these matters allows us to critically analyze the opinions of the other business valuation expert and to appropriately oppose those opinions in court if the case goes to trial. Perhaps most importantly, we pride ourselves in our ability to communicate with our clients. We're here to make sure that you understand the basis for the business valuation and how that valuation fits into the case as a whole. Your understanding is critical in allowing you to make an informed decision about whether to settle the case or go to trial. If you are looking for an attorney to assist you, please call us at 703-222-3333 or complete the contact form on our website and someone from our firm will contact you.